What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to talk about dealing with a difficult witness. I've given an analogy in the past of when you're in mock trial in law school and you have law students that are playing lawyers in a pretend trial, they are also playing the pretend witnesses. And there are some major issues when that happens. We're going to talk about that, compare and contrast Dr. Welcher with that on Cross. But before we get to Cross, there's some big things that happen at the end of Direct. So make sure you guys hit the like button. Make sure you get your questions in because I think this testimony and this witness brings about a lot of questions that I've been seeing float around on social media that I think are really good discussion topics about how we move forward in a case like this when, this is potentially the most important witness for the Commonwealth. And when this is how he's acting, what does a jury think is the real question. Do they love him? Do they hate him? Do they trust him? Do they believe him? Let's get into that. So at the beginning of the day, Judge Cannoni had a decision to make, and tomorrow she has another decision to make, which don't worry, we're going to get to that, the voir dire, the questions, and what we think is going to happen tomorrow. And when we talk about the decision she was going to make, I kind of gave my guess as to what she was going to do. Let's listen to what she says. Then we'll talk about what is similar or different than what I thought was going to happen and whether or not I think it's the right decision.
All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his...
So he can testify that it's consistent with being in a collision. The vehicle is consistent with being in a collision, which is exactly what we thought he should be able to testify to based on his experience and what the judge already allowed, okay? We don't need to rehash whether or not he's a medical expert or should be able to testify to this or that. We've already made our comments known on that. But where we're at in the trial, the decision that Judge Cannoni has before her, that's what we're talking about here. I think she made the right decision for him to be able to say is consistent with, not that's what happened, to a reasonable degree of scientific certainty.
His opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application.
And again, do you see, it's a little bit vague what she's allowing him to testify to, but is consistent with being hit by a vehicle like Ms. Reed's vehicle. Again, that is exactly what I expected her to allow. And I mean, I think that is very close to the exact questions Bob Alessi said, this is what they should be able to ask, Judge. This is what we're going to ask our witnesses. So I don't think there's a big surprise here. I don't feel like this is a big loss for the defense. Some people felt like it was, but this is what we knew Dr. Welcher was going to testify to. He just can't take it further than that, which she confirms here at the end of her ruling.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors are lining up. We should have them momentarily.
So that was her decision. And again, she said, basically, defense, you were right, you won, but not for the reasons you asked. Which is like, whatever. As lawyers, I can tell you we don't care. As long as we win the objection or the argument, or we keep the evidence out or get the evidence in, the judge can find whatever reason she wants to see it our way. But usually we are happy and need it to be seen our way so that we can further our case the way we think is appropriate for justice, of course. So the jurors come in, and Brennan has a few questions left on direct, and he was right. It was pretty quick, and we are going to listen to a chunk of it here.
Text stream data as well.
That information that you consider, in addition to the text stream data you consider, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
I thought that was kind of wild. 8 miles an hour to break the taillight lens. But guess what? I'm not an engineer. I'm not a scientist. I don't know how all that stuff works. I've never tried to shatter a taillight before. I know a lot of people have an idea of what they think it would take. I'm sure there's some jurors that have an idea about what it would take to shatter the taillight glass. Here's a question for Dr. Welcher. Why didn't you just do that little experiment and show us? And also, what type of item does it have to hit or be hit by at 8 miles an hour? An arm with, flesh and bones, a baseball, a bat, a sponge, right? Like, depending on what hits the light, it's not always going to shatter. So all of that matters. And he just throws it out there like 8 miles an hour. And all of us in our head are probably thinking, like, what were you thinking? Tell me in the chat what you were thinking. As far as miles per hour, I'm thinking 23.9 miles per hour.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, and inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Identical.
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to award that.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on sideswipe collisions or clipping. Can you describe to the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you're going to have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's the glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds.
So theoretically, she could have hit him at any point where she was going 24 miles an hour or whatever. And we don't know where it started from. We don't really know where it ended. We don't know where on the street he was. Was he on the grass? There's just so many factors we don't know, but he's just giving us all these things that could be possible to paint the picture for the jury that this could have happened in a car accident. Will that be enough to prove them and convince them beyond a reasonable doubt? That's going to depend on the jury. We had people commenting that's a clear view that this is how the injuries to his arm happened.
Without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars. There's most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact has occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle is going.
But not really. You notice how he said that? So here's what I noticed about this guy watching it multiple times and watching him yesterday and today. he chooses when he wants to be very specific. And a lot of it is, yes, when it's on Bob Alessi's questions. Vicky said, I swear the Commonwealth paid this guy to swerve every single question and to make his answer as long and confusing as possible. Can they do this? Yes. I mean, he can be a difficult witness. Now, it's a risk reward, right? Taylor said, my takeaway from Alessi having to rephrase questions over and over again was just hearing the info the Commonwealth seemed to want to hide 5+ times in a row. My perspective is, when witnesses act like Dr. Welcher did, was a very specific way on cross-examination, which was to not give an inch. If he used a word you didn't agree with, correct that word. If he pluralized something, bring it back to singular. If he said 2 things in one question, you said you asked 2 things. How do you want me to answer this? If he says, this is your number, say it's not my number, it's the number that resulted from my calculation, which again, kind of the same thing. But when you choose to do that, and you choose to be very hyper specific on cross, when he does stuff like this on direct, it's like, oh, if we would have had like a center mass impact or a direct impact, we could have definitely figured this out as long as we knew the point of impact and the rest. It's like, well, you didn't know that. So in this case, which is what we're actually here to talk about, you didn't know point of impact or point of rest, which you said is 2 of the things why you can't really give us more exact information than what you've already given us. So even if this was a direct hit in this case, you still would have the same problem. You still would not be able to do your job in this case fully because you don't have that information. But he just kind of glosses over and it's like, oh, one of the reasons this is so hard is because it's a sideswipe. It's like, no, if it was direct, it would be just as hard. But experts that use the language like this, very smart, trained experts, professional experts, this is what they do. You can notice the difference on direct and on cross. Not just in his demeanor, but literally in the words that he says when discussing the same exact topics on direct versus cross. Going to jump ahead a little bit. He says injuries are usually more severe when it's a pedestrian accident. That is direct contact versus sideswipes, obviously. But this was potentially the worst part of the whole direct. And it started out as something I thought could have been the best part of the whole direct, because I was like, oh boy, Brennan is going to answer some of the questions we had. Because these are the questions we had. How, why didn't he break any bones? Right? That's what we want to know. Why didn't he break any bones? Why did the injuries look like this? Explain that to us. I thought they were going to go down and explain it perfectly using another case. I was like, wow, Judge Cannoni's going to let them do this, because sometimes they won't let them compare another case because there's just, again, too many differences and variables, in a test case, not even a test case, an actual case he worked on versus variables you don't know in this case. So that could potentially confuse the jury, but Judge Cannoni allowed them to do it. And at first I was like, wow, this is good for the Commonwealth. Then I'm like, oh boy, that's a problem.
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side.
So Gian, this is my question. Gian said, I've been 100% not guilty since ARCA, but this expert did make me question what force is needed to break a taillight. My brain hurts. That's fair, right? And you've heard this expert, and you'll also hear from ARCA. You'll keep an open mind and make your decision. What I will say is all this guy did was say 8 miles an hour. He did not prove that, in my opinion, just like he did all of these other tests and exercises and experiments, whatever you want to call them. Why didn't he just do that on the Lexus that he bought? Why didn't he just go 8 miles an hour and prove to us you could break this? That's the whole point of him testifying. That was confusing to me. That seems very simple in his line of work.
In front of the vehicle at higher severities, their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it's not uncommon.
Have you had?
It's not uncommon, right? But then during cross, Alessi kind of argues with him. It's kind of hard to tell whether he agreed or not that lower extremity injuries might be more common than head injuries in pedestrian accident. So it's a little bit of back and forth on. Somebody said, Angie said, "Hi from the future. It's 6:30 a.m. on Thursday in Australia. Peter, love the channel. Regarding Dr. Welcher, one question. What did I just spend all night watching? Maddening. There was a lot that I was like, what did he actually say? What is he actually proving here?" Tanya said, even Annie Elise has admitted public perception is shifting and more people think she's guilty. Catch up, y'all. I don't really care what public perception is, right? I don't really care if people disagree with me in this channel. Annie Elise, Emily Baker, whoever it is. Like, everybody should look at this case and tell us what they think and how they think it's going, because the more opinions we get, the more likely we are to understand where the jury is sitting. And that's what I'm trying to think of. That's not necessarily going to affect the way I see it, but I think the perception of what's out there, every single person might be looking at something different and bringing their own experience to the table to help them come to that conclusion, just like a juror.
Add cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities.
Yes.
I'd ask you to turn to slide 139, please.
Oh, sorry.
Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted.
Okay, so what I'm going to do now, just because there's some awfully gory parts of this, let me show you just the I can't even tell. Is that taillight broken? Definitely doesn't look shattered like Karen Reed's, but definitely a huge dent to the car. So frankly, feels like a bigger hit than this Karen Reed case, which I think is part of what the Commonwealth was trying to show here. And I was like, okay, they're getting somewhere. Damage done to a car going between 25 and 30 miles an hour at impact, and the pedestrian was deceased after this collision. So let's watch. I am going to take it off the screen for a second because, again, it's for anybody that doesn't want to watch it or skipped it or saw it the first time and wasn't ready for it. They do show the pedestrian. I will describe it to you, what it looks like to help you, but we're going to still listen to it as they go.
Name at the top. This was an instance where we had, this is a image from the police report. Well, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit.
And you notice he's going to talk about area of impact, information they had in this test case that they did not have in Karen Reed's case, which is why I was like, man, I'm surprised they're able to get into this, but they are.
AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers. Hair.
All right, so hold on, let me show this part. So he's showing where the DNA transfers on this bottom right photo. Like DNA you can see with your eyes.
Hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case.
So now here is the person who was hit by the car, which we're not going to show, but I will describe it to you. It's gory. Huge gory cut to his arm, blood. And when they zoom in on his injuries, I'm going to bring the video back up and we're going to look into it to see if this said what the Commonwealth really wanted it to say.
Case, the person that was hit, he was killed at the scene. What you see on the left-hand image, oops, on the left-hand image is he had a massive laceration to
massive laceration.
His right forearm, but it didn't break his arm. There was no broken bones in his arm.
Which I think is a good point for the Commonwealth. No broken bones in his arm, and it is a much worse laceration from this. Looks nothing like a dog bite, I may mention. Looks literally nothing like a dog bite, or dog scratches. I guess unless the dog just bit a chunk out of his arm, but there's more.
On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, the buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, sure.
Do you want that expanded like other times?
There you go.
The judge, I didn't catch that the first time around. The judge asks to expand the injuries he sustained, which he said no broken bones in his arm or his legs. Okay.
Sorry.
Yeah, no, my pleasure. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures. If you look where I was talking about the multiple.
So let's take a second here. By the way, I would love to know if the medical examiner had any trouble finding out that this was from a car accident, right? Because that's the dirty little secret that we're not hearing in the background, that we're kind of meshing this all together. And again, also unfair of how I'm looking at this, because we have to understand I'm coming at this from all these cases where like it is usually very obvious if this happened in a car accident. We usually can prove with our expert that this happened in a car accident. And that's a trouble in this Karen Reed case. So let me pull the closed caption down real quick. All right. So head injuries, no doubt, similar to John O'Keefe. Fracture of right posterior ribs 11 and 12. Definitely something I would expect to happen when you get hit by a car as a pedestrian. Liver laceration, clinical. So from this car accident, it lacerated his liver. That is an internal injury that would have caused internal bleeding. This is literally what I was asking if it happened in John O'Keefe's case. Multiple abrasions, most of which, if not all, I can't do all these conversions, are bigger than the little bruise on John O'Keefe's knee. Right knee, left anterior leg, lower back abrasion, right lower back, left buttocks, posterior right leg, right ankle. Folks, if I am Alan Jackson or whoever is doing cross-examination, I am pulling this slide. I am blowing it up and I'm saying, members of the jury, this is what you expect to see when someone gets hit by a car. Rib fractures, liver laceration, bruising all over their legs and lower back and buttocks. Lower extremity injuries, 1, 2, 3, 4, 5, 6, however many there are. Count them up. This is what I would expect. And the truth is, honestly, the first time I ever looked at this case, this is what I would have expected John O'Keefe's report to look like. So I think this was potentially some of the best evidence for the defense in this entire case. Now, I think the Commonwealth did prove a point. I guess it is possible to get hit right in the arm at 25 to 35 miles an hour and not break the bone. I think it's very unlikely. But again, are we dealing in possibilities or probabilities? And that's something I would ask. Do you think it's possible to get hit by 25 miles an hour and not break your bone? Yes. That's why I told you guys, yeah, it's possible. Do I think it's probable? No, I think this would be an outlier. But even on this outlier, look at the injuries. This to me was some of the most important testimony of the case today and how I would look at attacking it as a lawyer. And that's why, like, a lot of the stuff Bob Alessi got into, we're going to talk about it. It's really a struggle with a witness like this at times, but this was huge for Karen Reed's team.
Full abrasions. So when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
Brandon's like, thanks a lot, Judge Cannoni, for blowing it up. Can we please take that down?
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body breaks to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a sideswipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Where were those red marks on John O'Keefe? So is it consistent? That was a horrible question, in my opinion. We knew how he was going to answer it, okay? And by the way, when lawyers sit over there, We know what he's going to say. This doesn't bother us that he's going to say this. He's the hired expert. He's going to say that. Our experts are going to say, what we have talked about in their report. But I would put that back up there if I was Leslie and say, is this consistent with being hit by a car? Is this consistent? Is this consistent? Is this consistent? So you would agree that John O'Keefe doesn't have any of this stuff. No lacerated liver, no broken ribs from the accident, no red marks and bruising here, there, and the other. All right. And that was basically the end of direct. That's what he ended on, was basically that chart. It's like, woof, not great. Before we get to cross, let's answer a couple questions here. If using a defendant's statements is valid for the accident reconstructionist, how do you choose which of the defendant's statements are true? She also said she didn't hit him. Case closed, not scientific. So Nick, if you notice what they do, and these pesky lawyers and experts, at the beginning, they say, I take into account and I consider all evidence, but only some of it is reliable. What does that mean? I pick and choose what I want to believe is reliable. Victor Perez, what's the point of being a difficult witness? Why not just answer the question and let the lawyers reframe the facts as they see fit? So let me give you some examples. This is a good kind of jumping off point when we get to cross-examination. Dr. Welcher is a difficult witness, no doubt about it. I don't care who you are. I've done this enough to know what a difficult witness looks like, and he is. You can say you think he was great. I'll disagree with you, and that's fine. He is not going to give an inch, like we already said. So what is the point? So let me tell you the positives about being a difficult witness. Number one, you can frustrate a lawyer and make a lawyer. Bob Alessi did not do this, but lesser competent or confident lawyers may move on if you're difficult enough. They may have a good question they want to ask you and talk to you about, and you're just like, forget it. I'm just going to move on. This guy's so difficult. Number one. Number two, if a judge is going to cut off a lawyer and you don't give them any ground and they waste a full 2 days, hey, they didn't get to what they wanted to. Some judges will allow that. We'll talk about whether or not we think Cannoni's going to allow that when we get to the end of the day. Number three, you can make the lawyer get fed up and look like a jerk. And the jury's like, why does this lawyer look like such a jerk? This poor guy's just doing his job. And you can twist and turn and talk so they are not understanding the answer to the lawyer's question. So those are the benefits of being a difficult witness. What are the negatives of being a difficult witness? Well, obviously, the jury can hate you. That's number one. Number two, you can look horribly unreliable and inconsistent if you were saying something on direct, which he literally did, and then said, well, that's a terrible question, or whatever he says. I have the quote in here that we'll get to, when Alessi asked you the same exact question and thing you testified to on direct. So you run the risk of that. You run the risk of annoying the judge. You run the risk of annoying the court reporter, which may not seem like a big deal, but if the court reporter tells the judge you're causing a problem, the judge may have to give you some instructions. You may have to sit there for 5 days if you're a difficult witness and the judge does what they should do. It's like, he's got more questions for you. It's a criminal defendant there. Their rights are very important. But obviously the biggest negative is you can look like a jerk. And that's why my number one way to handle a difficult witness, and I was kind of thinking about this. So if I'm going to give my spiel of how I think Alessi deals with a difficult witness, how Jackson deals with a difficult witness, and how I would deal with a difficult witness, and how it kind of is all a little bit different, Alessi can usually outsmart them, right? And he's going to use inconsistencies, trip them up, and make them look like a liar or like totally disingenuous, which I think he got at certain points. I do think he struggled at certain points. Jackson will either outbully them, he will overpower them, he will put them in a corner, but he also runs the risk of looking like a jerk. Alessi runs the risk of getting bogged down and making it clunky. So there's a risk and a reward to the way you can attack a witness like this. What I like to do, of course, control the witness when you need to, and outsmart him when you need to. Of course, they all do. We would all try to do aspects of this. I try to just outsweet the witness, right? Kill him with kindness. That's always what I try to do with a difficult witness like this, especially if I look younger than the witness, which hopefully I do with this witness. Maybe I'd shave my beard for day number 2. And I'll just say, doctor, could you please explain this to us? And he goes, okay, thank you, doctor. My question was this. Could you answer my question and then give your explanation, doctor? And just calm, cool, collect, sweet. Do not let him know he's bothering you. Make it obvious to the jury he is being a jerk on purpose for no reason. It's like, sir, I wrote down this question Mr. Brennan asked you. I'm going to ask the same question here. Things like that. Use things like that. And of course, they can object. Okay, that's not a question. Fine. Judge, I'm just trying to make this move along and get an answer to my question. You're not specific enough. It's like, okay, if I'm giving you a general question, give me a general answer. If I'm giving you a hypothetical, you're an expert. You should be able to deal with this hypothetical. Tell me what other information you would need. That's what I try to do. Now, I run the risk of that theory of the jury thinking he's dominating me, right? Which you got to be careful of. You don't want that. You don't want, which is why you got to push back at certain points. But you have to pick your battles on what you're going to push back on. You cannot make everything a knockdown, drag out fight with a witness like this. You just can't. You run the risk of they think both of you look like jerks. And guess what? He's gone after, I don't know, tomorrow or Friday, unless he's going to get up witness after witness after witness. So you really have to be smart about how you handle this, and you've got to think about it. And maybe the other problem is maybe Alessi really didn't know that it was going to be this difficult with this witness. And sometimes that can knock you off your feet a little bit, where it's like, crap, he's going to be like this. When you had a plan and now your plan's gone awry because he's choosing to be difficult, I would expect we see a kind, because Alessi can play the sweet card, the kind card with the genius card. So I expect to mix a little bit more of that in tomorrow. I expect to see a little bit less of the frustration and kind of loud. He does get loud sometimes to prove his point, but we'll see. Also with this witness, I'm going to summarize kind of the beginning of his cross until we get to the meat. I only think I answered one question when I said I was going to run through a few. Peter, were you as shocked as I was when I found out that in Massachusetts, an expert can testify to the ultimate issue? See, I don't really know if it goes that far. I didn't do all the Massachusetts research, but I think on ancillary issues to the ultimate issue, I don't think they could say Karen Reed is guilty of second degree. I don't think they can do that. Love getting your insights. My eyes glazed over during a lot of the testimony. What do you think is likely the jury did as well? Again, my guess is always going to be some jurors probably liked him, some jurors probably hated him. But there have been witnesses that are universally hated. Usually it's not an expert like this. Welcher said she backed up going 24 miles an hour on an icy road. That's so fast. Darrell Brooks was going about that fast. I hope the jury realizes how fast that is in reverse. So I had this car. My wife had it. To get that baby going 24 miles an hour, I mean, like in my Tesla, sure, I can get to 24 miles an hour in 70 feet or 80 feet, whatever it is. In that car, man, I don't think so. I don't know. I never tested it. Why was Welcher able to get new information added to his report, but Hank gets a second bite at the apple with ARCA? Because, and I think by admission of the defense, ARCA did more testing and has brand new analysis. Welcher and Burgess are like, oh, it's the same information. We just amended it or supplemented it. It's not something completely new. Can Welcher be reprimanded for being snarky, for his snarkiness? The judge could say, can you just answer the question or something like that, or give him some kind of instruction outside the presence of the jury. I don't think that's going to happen. I didn't watch the whole testimony today. Did he testify as to how the arm injuries are consistent with this scenario? We will get to that. Did you hear when Judge Cannoni called Dr. Welcher Dr. Burgess? I don't think I heard that. It was right as he was reviewing the contract he signed for $300,000. We are going to get to that contract. Are the experts able to omit reenactments or replications that did not prove the point they are trying to prove? So they don't have to present it as part of their presentation, but if the defense asks about it, they do have to answer and talk about, what the other demonstrations showed. All right, let me get to this cross. So Welcher, with kind of a pro move, is like, we weren't actually formally introduced. He's like, I'm Bob Alessi or Robert Alessi. So I was like, okay. I thought Welcher was maybe going to kill him with kindness and, out professional and outclass Alessi or try to do that. He decided to go a different route. He tried to be objective and seek truth. Of course. They discussed confirmation bias, failure analysis. There was a weird back and forth about, you don't ask what happened till the end. These are the things I wouldn't battle an expert on personally, of whether you ask what happened in the beginning or the end. What did you prove by that? I'm sure people that are just absolutely love Alessi are going to tell me it was an amazing, brilliant question. People that hate Alessi are going to say it was so dumb, he got lost in it. I just personally didn't think it was a battle worth picking. That's just my opinion. Are you familiar with Joseph Paul? I was like, here we go. We didn't fully get there, but we'll talk about that later. You were hired in September of 2024. Then we get into payments. In criminal cases, payments are not always a thing. So I do wonder how often all of these lawyers deal with these kinds of questions with experts. I do it in literally every single one of my civil cases. They do it to my experts. I do it to theirs. $44,000 sounds like nothing to me. Most of the experts I deal with have made $3 million over the last 3 years testifying for the defense. But regardless, you have to do it a certain way. Most experts are going to say, I don't know how much I've been paid. The company gets that money, not me. Okay. And I'm like, oh, you don't get any money for working on this case? You can make them look like jerks with simple questions. Okay. What's your hourly rate? $500. How much have you billed in this, or how much have you billed in this case? 10 hours. That's $5,000. You'd agree with me, correct? Yes. Okay. So whatever that number is, you can get it in there. And they usually have to produce their invoices, what they billed. Doesn't matter if he got paid it or if Aperture got paid it. So you ask those questions, you set it up, and then you move on. They got paid $44,000. Then you can also say, you bought a Lexus on behalf of the Commonwealth. A brand new Lexus or whatever it was. I wouldn't even get into the price, get into the, we're going to sell it and give them the difference. It's like, you bought a Lexus on behalf of the Commonwealth. That has enough effect. Getting into the specific penny or whether he knew it or whether he gets it, to me, is not as important. And again, we do this all the time. And I've talked to a lot of jurors. Some of them don't even care. They're like, I don't care that they were paid. I expect them to get paid. He even said something like that. Like, I'm an engineer. Of course, we're going to get paid for the work that we do. And it's like, okay, fine. Unless he also said, you've been on this case for 2.5 years, which was just dead wrong. And Welcher, of course, took that opportunity to say, sir, you are absolutely wrong. I have not been on this case for 2.5 years. I've been on this case 8 months. And it's like, oh man, that one hurt. That one hurt to me. Because again, the jury needs to find Alessi credible. And I think he's been incredibly credible throughout this entire trial. I think it was either a misstatement, which he tends to do once in a while. I said, my dad does stuff like that. Great lawyers misstate certain things. There was a certain time where he was like, I'm not talking about the tailpipe. I won't ask you another question about the taillight. He clearly meant tailpipe. He had just said tailpipe, but it's like, just got to be careful. How much is the jury paying attention to every single little detail? And I would say, you expect to get paid what you bill. It's like, well, we don't know if we don't get paid until a year later. It's like, sir, you expect to get paid. You billed $44,500. You expect to be paid, right? Right. Okay. And you move on. Whatever. If it's more people, whatever. Okay. You just deal with it one by one. Then I didn't even know about the $325,000 contract that he authorized, or that was authorized for them to spend up to. That's a big number, right? And I would also say, you're billing right now as you sit here, sir, right? Every day you're here, you're getting paid for that. Yes, I deserve to. I'm not saying whether you deserve to or not. I'm just saying they are paying you to sit here and speak. The $300,000, it's a lot of money, right? For just 8 months, it's pretty close to $3 million over 3 years, right? A lot more money. A lot more money. And of course, and people are going to disagree with me about this stuff, and that's fine. I'm just telling you, I thought it came off horribly clunky. I thought he lost almost all of the effectiveness with the $44,500. I would have brought the $325,000 in much sooner if I had it. But by the time he got there, maybe it still had that effect. When did you make changes? Again, this was another clunky part. Changes weeks ago. Changes because the judge asked me to. Changes because you guys asked me to. When he very specifically wanted to know about the changes he made. Peter, his company Aperture has been on the case 2.5 years. He has not. And that was the question, is he's been on the case 2.5 years. I also don't remember him clearing that up. So again, somebody may have heard it. Somebody may not have heard it. Wasn't clear to me. It was clear to me that this person on the stand you're at, and you have to be careful. This person, because you give him a way out. If you talk about Aperture, you give him a way out. You have to stick to him. You have to know that. You got to stick to him. And eventually they did. Removing the headers, the judge wanted me to. He let him dance, right? And he's going to dance as much as possible. And that's the difficult part as a lawyer to deal with. A witness that can effectively dance. Submitted a report during trial. Have you ever done that before? I've amended reports. Amended analysis, yes. Not amended reports, which I thought was great. I thought that was great that he got him to admit he had never amended a report before. Burgess, same thing. Then he talked about getting emails from internet trolls. Like, did you know anything about this trial? He's like, no. He did get Burgess's report. He did know about that. They talk about key cycles. They start talking about what the Commonwealth alleged throughout this case. They go to a sidebar. He tries to ask it again. They stop it again. And that's something that they're going to talk about later, that we're going to talk about at the end of the day today. Then he talked about the eye lining up with the spoiler. And then he said, I went to the property, and Leslie's like, we didn't step foot on the property. He's like, I didn't need to. I stepped on the street and I used the lasers. And again, there's a lot of back and forth here, which I thought was a good point by Alessi, that like you went and stood outside and looked at the property. There's no difference between doing that and taking a picture. It's not like you went around, you touched this, you searched this, you looked at that. So I thought that was a good point, although again, a little bit clunky. He didn't take into account the berm. Was it on the ground? Was it on the curb? Where was John O'Keefe standing? Where was the Lexus, et cetera, et cetera. Then we had the lunch break. And then we get to some of the meat that I really wanted to talk about in this case. Let's answer a couple questions before we jump in there. KR's car had adaptive variable suspension height control, and both have a substantial impact on the specs. Was that discussed today? If not, calculations are wrong. So basically the way Welcher would have handled that, I know, because it's how he handled it with the berm, is like, well, maybe John O'Keefe was standing on his tiptoes. Maybe John O'Keefe was on the curb. Maybe this, we just don't know that stuff. And it's like, well, then doesn't that prove what you're saying doesn't make a lot of sense? Did you notice Hank Brennan's reaction during voir dire when, I'm going to talk about this when we get to the voir dire. Cross is scattered, shows poor grasp of physics, and avoids important questions. Force, fracture, taillight, bruise. For pointless topics, confirmation bias. I'm 100% reasonable doubt, but is D afraid of the answer to some questions? Well, any lawyer might be afraid of the answer of some questions. I would not say it shows a poor grasp of physics or avoids important questions. I think it's taking him longer to get to some of the important questions that maybe some of us want. I do not think he's avoiding a single question. Do we know if Welcher is a licensed professional engineer for his discipline? If he is not, he should not call himself an engineer. I haven't looked at his resume. Peter says, Dr. Welcher used car damage pics of another person's body as an example. Can Dr. Russell use people's dog bite pics? She should be allowed to. It's a case I worked on. Here's a dog bite. More telling of what the Commonwealth didn't have him test? No. I mean, it depends on the juror, right? Are they going to think that? Maybe. Hypothetical, if John saw the car coming, stuck his arm out behind the Lexus with his drink, like Welcher said, then fell back, is that really manslaughter? I don't actually believe this happened. I think that is an argument for manslaughter. Yes, I do. Hi, Peter. Would you be happy if your expert behaved like this on the stand? He seems overly combative for the questions being asked of him. Am I wrong? So I've actually had an expert that I've had to have a conversation, brilliant Ivy League trained surgeon. Okay. And I've had conversations with him on certain cases being like, I love how confident you are. I love your personality. I love how you're handling this, but try to be a little less combative. You don't have to argue about every little thing. Don't be condescending, because sometimes, people can be condescending in different cases. And I've had this specific expert on other cases since then, and it's A+. First off, even those cases we won and did very well on, but you can still critique even after a win. Just because you win doesn't mean everything you did right. You did everything right in that trial. So if he was my expert, I would be like, hey, let's talk. Like, really smart, really great with this, really great with that. Don't tell him it's a horrible question, right? Don't say that. That's unnecessary. And it could twist some jurors the wrong way, or we just don't want to do that. That's not necessary. You don't have to do that. So absolutely, we'll talk to our experts. If you want to call that coaching experts, fine. But, they're engineers. They're doing math and science. It's like they're not all, well molded at the very beginning. They get better with time. Okay, let's get to part of this cross here.
Bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now,
He likes to say that we didn't have enough information, but you had enough information to say it was probable exactly what the Commonwealth's theory was, right? Because for me, you don't really, based on what he's saying, and this is my brain, right? Which might be very different from yours or a juror's. It's like, if you don't have enough information to talk about all these other hypotheses that I want to talk about, which is what Alessi's trying to get at, how do you have enough information to tell me that it is consistent with this? You don't know if John O'Keefe was standing here or there, if his arm was in or out. So you're just making stuff up to fit your theory. So we can do the same thing with about 50 other theories. Isn't that correct? Including a dog. I would leave the last part out. But there's a lot of other theories that can fit in if we change one aspect of, or one variable. Missed much of today's testimony. Thank you, Peter, for bringing us all together now rather than tonight. Needed my lawyer, recap. Shout out to Katie, my trial buddy.
Given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, Mr., and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds.
So I will tell you, Alessi, fine, definitely smarter than me. I never try to do the like physics talk with them or the Newton's law or act like I know it better than them. I like to bring it, in case you guys can't tell from my channel, I like to bring it down layman's terms. Let's talk like normal people and explain how this happened. And it's like, you had to do stuff with your arm to change your calculations, right? You had to go 2 miles an hour to get it to stick on there. You change any one of those variables and this is all different. I like to personally, and again, it depends on the jurors, and you guys might love the way Alessi does it. I try to really dumb it down as much as I can for myself, not for the jury. Easier it is for me to understand. Usually the easier it is for the jury to understand. Definitely the easier it is for me to argue to the jury. But Alessi loves to, really get into the weeds, and it's probably because he has a lot more knowledge and understanding about this stuff than I do.
Pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the...
So again, if I'm going to say stuff like that, I'll be like 10 milliseconds. It's pretty quick, right? Like, so the jury knows, because it's like, sounds quick, but I don't know, 10 sounds like a lot. Like you have to kind of quantify that stuff for us. Make it blatantly obvious.
G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
And so there's a bunch of people that have issues with the berm, which was a big point made by Alessi. Steve said, do difficult witnesses think they're helping the case? I don't get expert witnesses being like this. So sometimes if a lawyer comes up with a good hypothetical, you want to try to say, oh, there's all these variables. Like, you got to tell me this, got to tell me that, because you don't want to give them the answer they're looking for. So that's how they think they're helping the case in situations like what he's doing here.
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of having holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Okay.
Tell me when you're ready, sir.
All right, so he does some calculations here. I'm going to skip past the calculations, if that's okay with everybody.
About 2,188 pounds. I made a triangular.
I also think the expert, I don't know, did a good job of making this very confusing and hard for Leslie to make a point, but a bad job if the jury hates him. So my last trial I had, a very high paid, high priced expert for the defense that I cross-examined. Older gentleman, been doing this forever. In our deposition, he asked me how long I've been doing this for, which I thought is always one of my favorite questions to get from an expert. And I knew how it was going to go at trial. The jury hated him. Brilliant. Again, smarter than me. Probably smartest guy in the room. Expert. I didn't try to get into some of the medicine with him. I just pointed out some very obvious things. It's very weird. Why no MRIs? Why do people get MRIs? If people have a lot of neck and back pain, people have surgeries, if people get injections and get their nerves burned earlier in their life, usually is that preceded by an MRI? Because usually if you have pain and the doctor wants to see what's going on, they get an MRI, right? It's like obvious stuff. I don't need to talk to you about all the anatomical stuff. And he's going to bring in all this, this part of the spine does something like this, and this part of the spine does something like that. It's like, okay, fine. Jury doesn't even know what you're talking about. Let's talk about pain. Let's talk about this accident where they were wrapped around a telephone pole, literally, and they were saying this injuries didn't come from this accident. Use common sense in your questioning, and I think that can go a long way. Even a very smart, even a very good expert, sometimes a jury can hate them because of their demeanor. Seen it happen.
Crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical, semi-algebraic application of the numbers, correct? You
Correct.
divide.
We're doing a little simplification in terms of the crash
Yeah.
pulse shape, but generally, yes.
Right. So, but let's take the conservative number, the lower number, 2188 that you came up with.
Yeah, and he tried to qualify things like this, Maria, as saying, it's not right. If you do it wrong, it will create data that's wrong. So that's why we don't do it that way. But see what other people heard.
Do you know from the literature, as you did with a head, you went to the literature and said, this is how much pounds of force, if you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to do your calculation?
No.
I'm asking about...
And that's the other thing, if you're a lessee, the problem with so many hypotheticals like this, he can change one little thing and still saying the same thing. So say, well, you didn't say that, so I had to add that variable. And again, you guys tell me how effective you thought this was, right? How effective of a cross-examination you thought this part was. To me, when he started getting into the 300 to 700 pounds of pressure or whatever force on the hand, a little bit better. The point that the arm should have broken, I think, is a good point. This was not the easiest way to get it across. To me, it was still a little bit confusing. Just my point or my thought.
A center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals,
yes,
and metacarpals, intercarpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from...
He's asking another good question. Distributed loading. It's like if I stab he's about to give the example, if I stab the pencil in my hand, it's going to be a lot easier for that point to go in my hand. But if I do this, it's a lot harder to go through my hand. And he's right. But it's like, brother, you know what we're talking about. A car hitting an arm. Let's talk about that and that pressure. And unless he's given him too many outs. But again, that's what's difficult with a witness like this who knows the variables and knows how to be non-specific on purpose. And unless he's trying to get kind of logical, common sense points out, but the witness is not always going to give you that. And unless he battled and he didn't give up, he didn't move on until he got the answer he wanted in a lot of these points. It's just a difficult witness. I'm not saying I would have done 1% better with this witness, right? He was going to be a difficult witness no matter the lawyer that asked him questions. I think one of the thoughts tomorrow, in my opinion, for Alessi should be make sure the jury knows what a jerk this guy is. Regardless of the points you get out, make sure the jury knows what a jerk this guy is. And we're going to contrast them with Arca.
In the literature, not a calculation. Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay. But do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load,
P.S. When he realizes this ain't going his way as Alessi, I am assuming, this is an assumption, that he's going to ask the ARCA witnesses these questions. And they're going to be able to say, oh yeah, you can break your hand hitting a car going whatever miles an hour. So just get it out through them. Why do you have to make this guy your witness? He's not going to be your witness. So get what you can, pick your battles. That's honestly how I see it.
across the hand, there are distributed load tests that show you need.
I keep saying that's honestly how I see it. I'm going to stop using that as a crutch. That's very obvious that that's what we're talking about in this video, as I'm telling you what I see. And I'm being honest.
For 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight? No.
No, not a distributed load. A load from a motor vehicle going backwards.
Right. That's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're going to need higher.
How about another part of the on, if we can, just the calculation? So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading. You will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight, Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone. But as you got above 350, you started to break bones.
So if you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get
Even the way he says new,
3,600
like my dad, when he tells me I'm wrong, he's like, new.
pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds.
Tell me this while we're listening, because Lauren Boborin said, I fell out of my chair at almost $400K for 6 months. So help me out, because we've talked about this in the past. Some people seem to be very angry about how much this expert has been paid. So it seems like a lot of people didn't care, and this could just be, you know, people on Karen Reed's side, but didn't care how much, or that Arca was paid $23,000, did care that he was paid somewhere between $44,000 and $380,000 or something dollars. Do you care that experts get paid? Do you care how much? Is there a line? Do you expect them to get paid? Do you get mad if they pay too much? Tell me your thoughts on payments to experts. Do you just expect it? Is it fine? Is there a line where you're like, whoa, they get paid too much? I've also had jurors tell me the experts that get paid more, I usually think are better. And that's always, we're always like, oh, great, you know, because the defense is always going to pay them more because these insurance companies are shelling out money to these experts to do every single one of their cases. But tell me what you guys think, because I want to look at the chat here while we're listening, just to get a quick glance of what you think of the expert payments.
above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force
By the way, Leslie saying that is admitting we're not getting anywhere this way because it's too confusing.
that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was it? You said
2,180
dyslexic? Or did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
absolutely
so
not.
let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load in a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed. But what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far as my weight.
Just realized that pause moment. But I thought this was a good point by him. I thought it was a good point by him. I thought it was confusing the issue, not letting Alessi get his point. You can't just ask it this way. You need more variables, which is why if I'm Alessi, I'm moving on and dealing with this with my witness personally. That's what I'm doing. Ms. Mac, subscribe. It's free and you don't have to get notifications. Let's get Lawyer You Know to 500K. Yes, I'm really excited about this. There's not a lot of YouTube things that excite me. 500K would be wild if we get there. Also, we're at an hour. I still got a lot to talk about with this witness because yesterday I was frustrated because I wanted more. Today, I thought this witness put on a show. I think some jurors might actually like it. Some I think might absolutely hate everything about this guy. And that's something. So I probably know how this is going to go, but Kelsey, will you put up a poll? Did you find this witness likable, detestable, or mid? Just like somewhere in the middle, neither here nor there. Just kind of listen to him like any other witness. And will everybody hit that like button now if you have not already? John said, breaking down a trial, capturing only what the jury sees with zero outside noise, skip the lawyer's stuff, and zoom in on the evidence and testimony dropped in front of the jury. This could be a cool experiment for the future. I don't know how you do it without the lawyer's questions because the juror's hearing the lawyer's questions. Maybe you mean none of the outside arguments, none of the arguments about sidebars. Maybe, but I kind of think what people have questions about these cases, what are they arguing? What's the judge doing? That's kind of my value add. And you guys, frankly, give a lot of what you're asking for here. But if there's a way we can find something like this, I'm always game to try something fun.
Changed and weight is basically force. No, but I've distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper, potentially, yeah. But from a taillight or a broad flat surface, no.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe. That creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, sorry. Mr. Will, can you pull up a slide from Mr. Will?
So Alessi did say things like that to make this more efficient. Let me try this way. And that's kind of an indication that this witness is being difficult. They point to different areas he could have potentially hit his hand on the back to fracture it. So this was another, in my opinion, strong point for the Commonwealth. I mean, maybe I missed this last trial if it came out, but they're about to get into the fact that there were no x-rays of John O'Keefe's hand and arm, yet we've basically confirmed no fractures. And everybody's agreed no fractures. If I was I'll just tell you right now, and you guys probably would have thought Hank Brennan, if you would have been annoying if he did this, I would never stipulate to no fractures. I would say no x-rays. No x-rays. We don't know that there were no fractures. Now, you get into 24 miles an hour, it's going to be obvious fractures. You can see we're not talking about like hairline fractures, but x-rays would pick up hairline fractures, and maybe that would be something that would help the defense's case. But I thought this was a good point made by Welcher. Again, a difficult witness, not going to give an inch and going to argue about anything. The no x-rays part, again, I think that's something I would use if I'm the Commonwealth to say that doesn't prove there's no fractures. Now, great point. But why no x-rays? Well, that cuts against the Commonwealth. Once again, something the Commonwealth didn't do. Why didn't you guys take x-rays? And if I'm the defense, I would say it's their fault they didn't take x-rays. They should have. Then we could prove, but everybody knows looking at it, there's no fractures here. No bruising. You'd be able to see bruising, et cetera, et cetera. I'm assuming maybe the defense will be able to, if I was the defense now, I would ask my experts, what would you expect to see if there was a fracture? You would be able to tell X, Y, and Z if there was a fracture. That's probably what I would say. Where are we going here? All right, let's listen to a little bit of this back and forth.
You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records?
I get annoyed that he said it wasn't x-rayed, but this is something that I would be happy my expert did. Get into the details, be like, there's no like data for me to confirm with a test to prove there was no fractures. Everybody says no fractures, but and then when Alessi's like, are you telling me the ME missed fractures? Like, no. I'm just telling you she didn't do x-rays. Just telling you she didn't do x-rays.
In the autopsy that you say you reviewed, of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
Other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you
Again, I would have just been like, autopsy says no fractures and move on. But Alessi keeps pushing it to try and get that effect. Next witness says, Peter, you said at one point most jurors have their minds made up about a trial before closing arguments. So why would a lawyer leave a point on the table to bring up an argument? So here's what I'm saying. It's not so much leaving a point on the table if you're not making a point. Like, I don't think the point is being made with this witness as well as I expect Alessi to make the point with his own expert. I think he's going to drive this point home. So it's not necessarily leaving a point on the table. It's make the point when you can make it the way you want to.
Line, it's a question, that Dr. Scorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that.
I would say yes. She didn't look properly for a fracture. Because to rule out, how many people have had an x-ray before? How many people have hurt their foot or their arm and you might have a fracture? So what do the doctors do to determine if you have a fracture? They take an x-ray. That's the appropriate thing to determine if there's a fracture. But she didn't think this was a car accident. That's, if you want just my opinion, if I'm sitting back there, I'm like, she probably didn't x-ray all this because she was like, this ain't a car accident. This guy's arm's not broken. Nothing hit this guy in the arm going 25 miles an hour. That's why I think she didn't do an x-ray. But again, that's just me speculating.
Example, a hairline fracture. I didn't see any evidence that they actually x-rayed the structure. So there'd be no overt.
Headphones, listen. Come at me if you want to. I'm not saying you are, Miku. Come at me if you want to. I've been to the doctor before, okay? And I've broken bones. And I would not trust a doctor that went like this and was like, yeah, no broken bones, you're fine. I'd be like, I need a second opinion because I need an x-ray. You can have fractures without x-rays. Do I think that's the type of fracture that would come with being hit by a car? No, that's not my point, right? We're talking two different issues. Do I think this is some like proof that there was a fracture? Absolutely not. I'm just saying, as a nitpick that this expert decided to stick on and argue with Alessi, I thought it was one of his better ones because I thought a lot of them were horrible. But I thought this was one of the better ones personally, just my opinion. She did x-rays not to his hand and arm. They just said that. Didn't they? I mean, you tell me if there are x-rays in there, fine. And that would make more sense to me if they actually did x-ray his hand and arm because the Commonwealth has never brought this out before that I can remember.
Evidence of that?
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence.
Everybody's saying that she did x-rays and everybody's talking about ribs, specifically talking about the right hand, arm, lower arm, upper arm. That's all I'm saying. Okay. Alessi does not push back and say, here are the x-rays, sir, which is what I would have done if they exist and they show no fractures. And I think Alessi would do too. But I don't know.
And proof of absence of fracture.
I hope there are x-rays. I hope there are more data, more testing, more imaging, more proof of what actually happened. That's what I hope there are x-rays. And I hope they come out later. Just didn't sound like it from this exchange. And if a jury left this exchange, I think they're going to think there are no x-rays. What do you guys think?
So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I need to use proof for my question.
Ask me about the opinion of a medical examiner. I'm not a medical.
Time. Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for medical.
I understand. I think I've been doing that, but I'll redouble my efforts. Dr. Welcher.
Yeah, the judge, I don't think is happy about how this exchange is going either. At least she notices it. So at the end of the day, when we talk about what is still left to happen, the judge knows this is a difficult one.
My question. I'm going to repeat the question.
Mm-hmm.
Is there any indication in any medical record or autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
And that's what I like, that he should have done that before, because that's the point. He made the point. It's a good point. By the way, the poll says 3% found him likable. 81% hated him. 15% say didn't hate him or like him. So about 80% didn't like him. It's not great. It's not great for an expert, especially that you're paying this much money to. Peter, did you catch the court reporter throwing her hands up and rolling her eyes at the end of voir dire? I didn't, but just what we just heard from the judge and the court reporter, you can tell they weren't pumped about this exchange. Is his combativeness a common tactic? I don't know if I'd say common. I've seen it before to different levels. He's pretty frustrating, I would say. If I was Alessi all day today, I would have been really frustrated. I would leave today annoyed. There's another question I wanted to answer. All right, we'll come back to it. He said, okay, let's get to your blue paint exercise. He said it was a test. It's like, he can't even give him that. He's got to argue that it was a test, not an exercise. It reminds me of a cop I cross-examined once. Generally, he wanted to show the taillight basically just covers the lacerations. And then they get into, why didn't you do any testing at 20 miles an hour? And I thought another big snafu, not great from this expert.
Test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus taillight on that arm.
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. Yeah.
What? Got that from you, from the Commonwealth. That's what you guys have been saying this whole time. At least that's what I thought you were saying. I will admit it is a little confusing, but I literally thought that's what you've been saying the whole time. This backup triggering event that was over 20 miles an hour, the same time, 1231/1232, John O'Keefe's phone never used again. I thought that's what you guys have been saying the whole time. And he looked like disgusted at Alessi. He's like, where did you come up with that? I was like, that's not good. If I'm a juror, I'm like, wait, that's not what you guys are saying? That I thought was not great. Not great. Like if I'm Brennan, I'm like, that is what we're saying, dude. That is what we're saying. If it is.
Answer is no. So did you do a test involving...
Unless he was right. And that's what I would do. I'd be like, so that's a no, sir. It's all you have to do is say no. You don't have to say, where did you get that from? Right? Kill him with kindness. I want a lot more of this tomorrow. I think would go a long way for Alessi.
Miles per hour.
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mm-hmm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you? Of course.
Do that?
Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
Nobody expected you to, sir. Nobody expected you to. But you could still test it. Crash dummy, anything. Test it with a baseball bat at 8 miles an hour. I don't care. Show me how the taillight breaks.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you use the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
And that's what somebody posted about earlier in a comment. And you know what's so great about that? Again, just how I'm thinking about it, not necessarily how the jury is. I said I wasn't going to say that again, and there I am. So you didn't do it with the test dummy because you didn't know. Again, he put his arm out. He did this. It's like, yeah, you don't know if the arm was up or where he was standing. Was he on the berm or not? So you didn't do it with a crash test dummy because of all the variables you didn't have the answer to, right? Well, why then did you do the paint test, the blue paint test? You created some variables there. You bent your arm to a very specific area. You stood in a very specific spot. You rolled it against the taillight a very specific way. So you were able to do that test and say that that was able to lead you to a reasonable degree of scientific certainty that John O'Keefe was hit by a car that was identical to Karen Reed's Lexus, but you couldn't do it with the crash test dummy because there was just too many variables. That would have given me too much fodder for cross-examination. From ChatGPT, it takes about 3,000 to 4,000 newtons and roughly 675 to 900 pounds of force of direct blunt force to cause a fracture in the midshaft of the forearm. Right. And I wonder what it says about the hand, because Alessi was talking about forearm and hand.
So your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis.
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Do you know, you have a hypothesis at what speed you believe there was impact? Do you have a point of impact?
It's almost even worse. It's like they definitely have wanted the jury or us watching to infer he was hit at 24 miles an hour. Now they're like, we never said that. It could have been at any speed he was hit. Which I guess is true because she was going up to 24 miles an hour. But that's even less. Like if she hit him at 5 miles, it's just like, just highlights what they have not proven, in my opinion.
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Let's talk about the other information you don't have.
Okay.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, right?
Right, but I don't know where that is on the road.
You don't know that. I'm going to go through the information that you don't have.
Okay, nope.
So you don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
I feel like where it landed could help, right? I feel like where it landed at least could be a variable that could help you work in that direction. He's also very confident about 7 feet. I've seen people talk about how maybe he shouldn't be so confident.
Right. And you don't have that information.
I don't have where it started.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right. But my question, sir, I understand you.
All right, we're going to jump ahead a little bit to another kind of just snarky comment that he made. Because this really comes down to, like, what does the jury think of this guy?
Can you
Just hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
Again, and I saw people being like, oh, Leslie's asking horrible questions and nonsensical questions. That seemed as simple as possible for me. How many feet did it go in reverse? 87 feet. I like, didn't we just get that? I don't know why Leslie's asking again. I feel like we've already confirmed it went 87 feet in reverse. But this guy's like, your question doesn't make any sense. And once again, that's a jerky response to a lawyer asking you a question. Alessi is not trying to be combative with that question. Now, some of the question Jackson's asking, right? Like if he's trying to spar with the witness a little bit and the witness gets frustrated and says something like that, Alessi's really not doing that. So I don't know why this guy had that reaction. What does a jury think about that? I don't know. I also thought it was kind of simple. And he's already answered it a million times, 87 feet. So that was kind of a weird exchange. Then Then he talks about Alessi's like, how certain are you? Are you certain, or just kind of certain? Pretty certain or very certain? 100% or not? And I just didn't find that effective personally. They talk about applying heavy acceleration could cause the wheels to spin, which I think is good. And I think that makes sense. Again, he said 87 feet of backing. There were people inside 34 Fairview. Did you assume cars were parked out front from 12 to 1? He said at some point there was a car behind him, but it moved. It was an F-150 pickup truck. So I believe he's talking about Nagel at that point, but Alessi is talking about Higgins. If it would have gone back 50 feet and there was a car there, he would expect there to be a collision. And I think that's kind of setting foundation for what the defense is going to argue in the future, not necessarily proving there was, in fact, a collision. So, Valerie, I kind of answered this. I think she didn't think it was a car accident. She didn't see any evidence of broken bones, so why x-ray? It's probably what she did. Agrees multiple times that he doesn't know when the backup started. Could have been in the neighbor's yard, could have ended up in 34 Fairview yard, didn't necessarily have to. Driving backwards 24 miles an hour in a snowstorm with without clear visibility and low lighting. He's like, no, I haven't done that. Well, maybe I did when I was skiing decades ago. It's like a simple no would have been sufficient, sir. And then we're going to listen to this exchange about whether or not it's reasonable the car ends up on the lawn. Almost at an hour and a half. Hopefully we're done here in the next 15, 20 minutes.
No, there's some spots. If you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right?
Conditions have nothing to do with where you start.
My
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur a vehicle going
So again, I thought this was a miss by Alessi to say, isn't it reasonable that she ended up on the lawn? And he's like, no. He goes, you don't think it's possible? He didn't say it wasn't possible. And you have to be careful with a witness that is going to nitpick every word you say. In my opinion, again, the witness was right and Alessi was wrong on this part. I'm trying to show both, right? Where the witness was dead wrong multiple times, but Alessi had a couple missteps in this cross that are unusual for him, in my opinion. Because it's absolutely possible that this ended up on the lawn. Now, to Alessi's credit here, he's given a gift when they discuss what the possibilities are and where this witness decides to go.
24 miles an hour. Is that a reasonable conclusion?
No.
So you, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur a vehicle going 24 miles an hour at this location, 87 feet backwards in the dark with wet pavement at a minimum and low lighting. You don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn. That's not possible.
Your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible?
I get what he's trying to do there, but you probably don't want to throw that out, that it's possible it shot out into space. Because then the jury's like, I mean, the jury had to side-eye that, right? They had to side-eye that because we've seen some cases together. I don't usually love doing the whole, it's possible, right? It's possible. In some cases we've watched, they're like, oh, anything's possible because the lawyers just keep asking, is this possible? I don't feel like that's been the theme of this case. So for him to throw that out, not effective in my opinion.
Possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus
Touche. I think at the time, nobody thought that was a confession.
could have been shot off into space.
Yeah, highly, highly unlikely. But
Right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of the Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No. It could have.
Okay. Now let's go to the next topic.
All right. And we will also move on. Car hitting John O'Keefe would introduce rotation, horizontal injuries versus vertical injuries. I thought that was a good point. Welcher, once again, kind of mucked it up. But from my perspective, I think that that's, again, foundational. And unless he's going to build on it with his witnesses, and it's going to make a lot more sense, because I think that the whole placement of his arm, if I'm Arca, I'm using his own video to show why that doesn't make any sense with how the taillight broke. In my mind, it just doesn't make logical sense. Mrs. Meathook said, math nerds aren't happy you skipped through the calculations. Do you think he's helping the Commonwealth horrible? I definitely think he's helped on certain points. I think he's been potentially catastrophic for the Commonwealth on some points, like using that other case he had. To me, that's like one of my biggest woof moments of this trial, and one of my favorite pieces of evidence if I'm the defense. Say, this is Welcher's PowerPoint. This is the Commonwealth's exhibit. It proves our case. Alessi points out he didn't use the laws of physics with his right arm. We'll get into, I think this is kind of one last exchange between Alessi and this witness before the end of the day today.
So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific...
So that was an important quote, because the Commonwealth has to tell them what didn't happen, right? Either what did happen has to be so positive, which it's clear from this guy it is not. Too many variables, couldn't say, whatever, reasonable likelihood, whatever he wants to say. Very clear he's not saying he can guarantee what happened, although he tried to say that is what happened. But in order to say what happened, you've got to prove what didn't happen. And I will just tell you, folks, I have never had a car accident case where somebody was able to come and make a real argument that was a dog bite instead of a car accident. Never have I had a car accident case like that. So you do have to do that in certain cases, and this is one. This is absolutely one of those cases.
Method earlier has the scientist identify various hypotheses, go with the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with Alexis. I did.
So he's asking about specific, did you do this? And he goes and talks about all this other stuff he did that is not what Alessi's asking about.
Hacking test. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not. So I eliminated that as a hypothesis.
At least he confirmed that the taillight didn't just break on its own. I'm a STEM professional and student in Boston. I would never accept a job with this company knowing he's the VP. Can we actually see a taillight crash and shatter? Well, that would hurt the resale value of the Lexus and therefore cost the Commonwealth more money. It's like, yeah, that's what this guy does. They break stuff, right? That's what Arca's going to say. Pretty cool job.
I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where is the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
So, Mr. Alessi, I think if we're going to...
I'm going to move on, Your Honor.
So
Okay, but Mr. Alessi, hold on. We're going to do that for you.
Can I ask, I just have one other area, Your Honor. I can do it in short order if I could,
Okay.
please.
I wasn't finished.
Go ahead, finish your answer.
So slides 109, 110, 111, actually through, I guess, 121 deal with the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal.
He really stayed a lot on this. I think they kind of made their point, but letting the witness go through it again and again. Taylor, I thought forward plus reverse equals total distance 87. So did I. Baba D, I do my best, but I can't do everything with all the comments. Okay. I do my best, try to put them up there, react to as many as I can. The chat also is talking through them, but that's fine. Everybody got to do them, right? Deandra said, I'm already appalled at Bev rushing through tomorrow, and it's not even here yet. So here's what I think. We're going to talk about whether or not she rushed him at the end of the day today. It was getting close to 4 o'clock. She wanted to give the defense time to do this. It's a juror issue why tomorrow's a half day. And we'll talk about what Alessi did, which is what any good lawyer would do to make sure he does not get rushed tomorrow.
I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this will be my last question, did you engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
debate.
so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do here and we don't need you waiting there while we do this. So tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here we won't go until 4 tomorrow. Those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. 4th admonition, please be very careful with your social media.
All right. So we are going to get now to the voir dire. And just in case anybody didn't understand what they were doing or why they were doing it. If you notice a couple times during the cross-examination, unless you want to get into topics that the judge didn't let him get into, you have to build a foundation and make the judge and the jury understand this guy knows what he's talking about. He knows about Trooper Paul's report, for example, the medical examiner's report, what they said, what they did. If he doesn't know, then he's not going to be able to opine about it. If he didn't use it in his analysis, they're not going to be able to ask him about it the same questions they would if he was able to do it. So this voir dire was to try to determine how much he knew and how much he used from the medical examiner and Trooper Paul. So that is the setting. And sometimes it's not clear because lawyers and the judge will talk at sidebar. Then all of a sudden we're doing this voir dire in open court. But I want everybody to understand that as we go into the voir dire on this issue.
Dr. Welcher, do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced
Sir,
it.
I got to
don't
look at
recall
this quickly. That image is a drone image on the left, correct?
Oh, correct.
And you
He starts to figure out real quick. He's like, we're not in front of the jury anymore. I can be a little more forceful with this guy. He's like, don't dance. This is where a drone image, right? Where do you think he got it? Because he said he did not rely on Trooper Paul's report. That would be confirmation bias. He made sure he did everything else, or he did everything on his own and didn't just rely on what other people did. That was why he just didn't look at it. I'll tell you my thoughts on this as we go. I don't want to forget, but I'm trying not to rush through. I only have about 15 more minutes.
had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report? Do you recognize?
Back and forth a little bit. Was this in Trooper Paul? Did he remove it? Did he look at his own? Eventually they get to somewhat of an answer. We're going to wait and hear what Brendan had to say too, but some interesting back and forth here during the voir dire. But at the end of the day, the answer is yes. He got documents from Trooper Paul's report, or at least from the file. Let me listen to this part first, then we'll talk more about it.
Yes, it came in a file called cars-trp.jopal.
Okay.
Cars.trp Joe Paul. What do we think that means? Trooper Joseph Paul. That's where he got this information. at least some of it. And it ended up in his report. So he definitely used it in his analysis. In my opinion, I think Alessi set that up pretty good.
So it came from, and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes.
that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Can you read the file name again that you just read?
The folder name
Yes.
is cars-TRP period Joe Paul.
Okay. And
If I'm Judge Cannoni, that's all I need. I don't need, this guy can tell me it didn't come from Trooper Paul's report all he wants. We look at photos. Who is it? Trooper Paul's? Is it not? Then we get to the ME, Scorty Bello. You use information directly from the autopsy report because he wants to question him on these things. And then we get to Brennan, and let's listen to what Brennan has to say. He comes out firing. He's like, Judge, I got a couple questions I want to ask the witness. And he comes out firing, giving this witness the question. It's outside the jury's presence, so the judge is allowing him to lead. That's why there's no objections, and that's why he's allowed to ask questions this way.
Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report. And
Did you know that actually didn't come from Trooper Paul? It came from the CERT report. Here's the real answer. So what is Judge Cannoni going to do? He says he got it from a file that's called Trooper Paul. Trooper Paul maybe gathered this, used it, something. What is Judge Cannoni going to do with this?
Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was-
I absolutely was not relying on Trooper Paul. I did not. Brandon's like, you didn't use his analysis, did you? No way we didn't use Trooper Paul's analysis.
Simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted to be independent in my analysis.
Regarding Dr. Scotabello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion?
I think that's the question he did not want a yes to. Did you consider the manner and cause of death in your analysis? He said yes. So Hank Brandon can try to fix it all he wants, but Judge Cannoni should have heard that. He should be able to be asked about that. The undetermined. He should absolutely be able to be asked about that.
Analysis.
Regarding Dr. Scotabello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fracture.
Like, oh, no.
There's the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusion to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take.
Michelle, this is the part you were talking about. It's like, let me give him the answer because he's not giving me the one I want. And this happens at trial to Hank Brennan multiple times.
A person like that's opinion for that.
Did you ever have a conversation with Dr. Scotabello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scotabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay. And Brennan, that's pretty good job to get the information out that you want to in a short period of time to try and convince the judge. I think that was a good job, a great job, frankly, by him, because those are the answers he needed. That's what he needed to tell the judge. So I thought it was actually a great voir dire by Brennan. Mary Claire. So this comment about it being the Massachusetts taxpayer dollars, that's a common theme when we talked about paying experts. People were more annoyed that this amount of money was coming from taxpayer dollars, which is obviously different in my case, versus each party paying the expert.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just going to
I have
decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scorty Bello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here for the autopsy report.
I only paid attention to the portions that were good for me, and that's what I used. It's like you can't really do that. You shouldn't be able to do that. We'll see if Canoni allows that.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Woke. But you recall the slide that you had has the final diagnoses of Dr. Scorti-Bello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You
Correct.
considered that.
Correct.
Thank you. No
You're
questions, Your Honor. I
All
appreciate
right.
that.
So I'm not going to let you argue now. I'll hear you very briefly.
That was a great ending for Alessi, especially for the ME. Here are my thoughts on whether or not he should be able to ask questions about Trooper Paul. To me, absolutely. At the very least, you say, you give him Trooper Paul's hypothetical, let him smash it or whatever he does with it because he's an expert. You can give him a hypothetical. If the judge doesn't allow you to connect it to Trooper Paul right now, that's fine. You can have your expert connected to Trooper Paul later, who is also going to disagree with it and say that was Trooper Paul's report on this date. Their expert should absolutely be able to respond to what Trooper Paul said, should absolutely be able to discuss what Trooper Paul got into evidence, which is why, I mean, from my perspective, you should be able to ask this witness, but that could come back to bite him on rebuttal if they do recall Dr. Welcher. I think the defense should ask them about Trooper Paul's report even more. All right, let's get through some questions here. Hit the like button, guys. Hit the like button if you haven't already. Do you think this hurt the Commonwealth? I feel it was worse than JM. He was very indirect and argumentative. Do you think this young jury sees through his BS? How do you see this moving for the Commonwealth? Again, he's the type of witness I think some jurors might love, some jurors might hate. It's impossible for me to say the entire jury will love him. I thought he was way too combative. I thought he made points for the Commonwealth, but I thought he was too combative. Izzy, the defense should definitely start their case with ARCA to put this travesty of a testimony to bed. Peter, what do you think? Who do you think they'll call first? Thanks. I just don't know. I haven't sat down and mapped it out how I would do it. I've talked about it with Betterow and some other lawyers on other videos that you can check out, but I haven't really thought through it. Taylor, do expert witnesses have to disclose all the tests they conducted to the side that hires them, or can they pick and choose, including the test? They don't have to prove their theory, don't have to be disclosed. So that the testing, it depends. Sometimes they have to turn it over to the other side. Sometimes they have to turn it over to the experts on the other side. It depends on the jurisdiction. Jamie, Peter, I watch trials like this. I watch trials like it's my job, but it's not. That said, this guy is just the worst. Does it mean much that the Commonwealth didn't object a ton during cross? I think it means this expert can kind of handle himself. Did Brennan ask for a mistrial, double jeopardy? People sent me this clip. He very clearly to me asked for an instruction, and the judge said, I'm not going to give an instruction, not a mistrial. When questioning Jen McCabe, the defense called the FBI separate law enforcement agency. Will the judge allow the term when ARCA testifies? I don't think so, but I don't know. If she does, that's a huge win for the defense. Follow up to the Runkle video. Anything new proven today? I think they proved it's possible that a car hit John O'Keefe's arm there. I think they proved it's possible the car flew into outer space. I think there were some good points made by him about the no x-ray, about what we do know, what we don't know about where the car was. The fact that 8 miles an hour can shatter a taillight. If you believe that and he proved it, then that could be a point for them too. Can the defense use the dash cam video that shows Karen panicking, but never once saying I hit him from the ID channel documentary? Again, if these witnesses say they heard it, it could have been off dash cam. You definitely couldn't hear everything on dash cam. So I don't think that would be that effective in my opinion. If the Commonwealth's own timeline keeps shifting, how can jurors feel confident and guilt beyond a reasonable doubt? Isn't that the whole standard? This is great. This is scary. To some jurors, that will be enough reasonable doubt. To others, it won't. And that may sound like a cop-out, but that's been true in other trials. Where the Commonwealth get its money worth to save pigs' face? Taxpayers. Touche. It's just me, or is too much of Aperture's testimony because I said so? That plus Hank Brennan's obvious surprise by answers that he doesn't lead makes them a hard sell even without the egregious credibility issues. How about the rebuttal? evidence. Brennan brought up to him before when being on the stand in April. Some get the judge, but she comes off bad. So yes, everybody knows that he gave that over to them, but he said he wouldn't have time to evaluate it until after. That's why he gets rebuttal. But what I will say is anything that is brought up now, even if it is that rebuttal evidence, should not be allowed to be brought up later. Does the prosecution expert get paid by the taxpayers? Yes. Unless there's something I don't know there. Kevin Martin. So given that distribution argument, it could not break a bone. Wouldn't that apply to the tail light? So how then did it break? It's a good point. Was it just the knuckle that broke it? Was it the glass that broke it? Describe to me the load distribution that caused that break. It's a great question. Are there other videos of the paint test? I'm sure it took a couple takes till he got it correct. Let's see all the videos. I don't know the answer to that. Peter, can Alessi ask the judge to tell him to stop with the side comments? Glad I'm not the only one who's having trouble. He is such a jerk. Hated him. Yes, but you want to be careful to not let this witness know he's bothering you. But we've seen lawyers say, strike that part of the answer, judge. Can we instruct the witness? Maybe ask at sidebar. A main question missing, how did the tail light break? Evidently, the Commonwealth filed to keep out a key piece of evidence. Can you look it up? I do not have time to look it up right now. Somebody can send me the motion, though. Peter, are you aware of Carl Steinbeck, Esquire, found Massachusetts case law wherein this witness was disqualified as an expert due to invalid scientific method? I'm not aware of that. I have not seen that. Peter, as a fellow pickleball fan, what lawyer on this case would you want as a doubles partner? Gosh, it's hard for me to pick. Alan Jackson seems like a killer. Bob Alessi seems like a real health nut. Maybe he's athletic. I don't know. Who's the tallest with the longest reach? That's big as well. After x-ray, it took 3 reviews to say that I actually had a broken bone. I've had that happen to me before. From the same shots, is a full body scan required? Unwitnessed death? No, I would not say it is. Is it common to x-ray the deceased? Sounds odd. Yes, it is common depending on what they think happened, what the circumstances of the death are. Could he be bordering contempt? I really don't think he's gotten that far. Didn't know Higgins' Jeep was there. Well, some witnesses said it was, some witnesses said it wasn't. Bob Jr. Hi, Peter. Sorry I'm late to the live. It was movie Wednesday. Lucky you. Do you think AJ would have done better with this witness? I guess Bob is only halfway done with the witness. Love your shirt. It's fire. Thank you so much. It's always hard to say, to Monday morning quarterback it, but Alessi was the one prepping it. I think Alessi is really good with these experts, so they're probably not second guessing it. Why didn't the judge admonish him for the comment about the Lexus being shot to the moon? Because he's allowed to say it, and I think it was a bad comment for him. So let him go. I think Alessi liked that comment. Peter, should we all ship in for a trip to the batting cages for Alessi to blow off some steam after this? He's probably going to go back and prep. Preparation always calms the nerves. Taylor, can they ask, are you saying that the Commonwealth is arguing happened is one of infinite possibilities of what could have happened? Yeah, I think they can ask that question. I don't know about infinite, but of many possibilities. Didn't he probably say it's probable? It's reasonable and probable. Didn't he literally just say, I didn't do the test with the actual data because I'd have to defend myself with it? Case over. How do you indicate where he landed? Where Jen McCabe said she saw him that morning. That's, I think, where it's indicated. It takes 200 feet at least to reach 24 miles an hour from a Google search in reverse. Does that disprove the trigger event measurement? I think the defense needs to bring that out with their experts. Peter, did you think it was cringy when he wore the clothes matching John O'Keefe? Yeah, a little bit. Epic. It's my first ever live trial. I'm confused. This guy based the whole thing on assumptions where we're based on testimony that changed. They've all admitted to changing things, even Welcher. Sus. Will R. Peter, his opinion expert is based on so many assumptions and tests that are designated or designed only to back up his assumptions. But are they probable? He would say yes. And he would say that's the big difference between possible and probable. Woof. We need a woof. Don't know if it was asked, why didn't the defense move to declare him a hostile witness? You don't have to. You're already cross-examining him. Azam asked that question too. Hostile witness is usually when you're on direct and you need to start leading the witness. Every witness for the other side could potentially be hostile. Sean finally became a member today. We disagree on some things, but that's how we learn best. Thank you, Sean. Perfect example of that. Are you doing your collab with Ted Daniel tomorrow? Looking forward to it. I enjoy your objectiveness. I am on vacation tomorrow. I don't know if I'm going to be able to make it work. Peter, can the lawyers change who questions the same witness the next day if they want? No, not usually in the middle of a witness. They can change like before a witness starts, like I was supposed to, but Jackson's going to. I've actually done that in trials where I get so crazy and taking all these notes. I'm like, Pete, I'm going to handle this witness. Never has it gone the other way where I don't handle the witness I was preparing for, but sometimes I've taken a witness. Peter, I have 20 years of treating trauma patients at bedside. Any expert who says John O'Keefe's injuries are consistent with a car versus pedestrian is a liar for hire. Is there a real reason Bev needs to be finishing the day at 4 on the dot and freaks out if not? Is that not as early for a typical 9 to 5? So yes, every judge is a little different, but once you tell a jury what to expect and they make plans, maybe there's childcare, other issues, usually you want to stick to it for the jury's sake. I like the jury heard there was a dog in the fight. I did think that was whenever I say that analogy, I cringe a little bit. Azam, 500K subs in 5 days is possible or probable? I don't know. You guys tell me. Are you guys all subscribing right now? How many mistrials can there be with a case? So there's not usually a limit according to case law, but the interest of justice sometimes can step in. So much reasonable doubt. New to your channel. I'd like to hear your perspective in this case. Thank you, Jeannie, and welcome. Over 300K for these two guys. Good grief. Peter, have you ever heard the other side's expert go to your side? Yes, actually that happened in a case so much so that I wanted to mention him in opening, and the other side was like, you can't, we're removing him as an expert. We're not using him. You can't mention him. They didn't get to hire a new expert, but I wasn't able to bring it up because he was completely removed from the case. If they would have brought in a new expert, I would have asked that expert about the old expert's opinion, but they just withdrew the expert opinion altogether. And his tests try to prove the Commonwealth theory, arguing he seems biased with an agenda. Hope the defense opens with ARCA to highlight the contrast with real professionals. Did you catch the part when he said he didn't think most of the testimony he saw mentioned the Jeep? I think it was. Doesn't that sound like a possible violation of the sequestration order? So he was able to review the testimony, probably the testimony from the first trial, didn't watch the testimony from this trial. So if he's wrong, then the defense can point that out. I did biomechanics research for 15 years. Drop a cushioned object from 2 feet. That's 8 miles per hour. Dr. W shows no experience of the most important questions. I thought key cycle 1162 was from when the car was towed at Karen's parents' house. Trooper Paul said he created key cycle 1164. That means the trip to the Sally Port was 1163. I got to be honest. I'm not sure. That's confusing to me. I'm not sure. I can't give you a good answer to that question. I apologize. But I assume the defense will bring it up if it is an issue. Why wasn't Alessi allowed to ask about the changing timeline after a sidebar? He had to move on. That's what the voir dire was for. Can they get into what Trooper Paul said happened and what Trooper Paul's theories were? Thanks for the recap. I tuned it out early on this morning. I wonder if the jury did too. It was terribly annoying. It's possible. If you did, potentially a jury would. Why is Hank Brandon allowed to give the answer everyone he directs? Would other judges allow this? Surprise, no. Whole body scan and ER with ME with trauma. So he did that. He was allowed to do that during the voir dire outside the presence of the jury in order for efficiency to move it along. John O'Rourke, did I miss it? Can Alessi discuss Trooper Paul report with Welcher? We're going to find that out in the morning. Dora, Peter, are you having any guests or appearances on? None planned right now. We'll see what happens. I'm sure there will be more in the future. That is the last question. I got to run. You guys are the best. Hit that like button, subscribe, do all the YouTube stuff. I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.